This presentation will discuss negligence law and no-fault compensation for Queensland police officers affected by PTSD. In a video interview on police trauma and PTSD, Detective Rob Davis describes his own stigma. We have all these military vets in our department that saw battle, and they're all fine, and here I am struggling. I just got shot in the leg. It wasn't like anything crazy like these guys have experienced. It was humbling and embarrassing. This presentation will cover the importance of understanding negligence law as it relates to psychiatric injury in the form of PTSD by employees of the Queensland Police Service. The current state of legislation in this area will be discussed, as employees may have a choice between a common law negligence action and compensation under the no-fault scheme. The current effectiveness of QPS in monitoring and addressing employee mental health and illness will be discussed, and suggestions will be made for improvement. It's imperative to the well-being of the public, to society as a whole, that police officers are mentally healthy. The demands of the job require first responders to think clearly. This is especially crucial for police officers who carry firearms and who have the power to apprehend, detain, and arrest members of the public. Further, the costs of psychiatric injury are disproportionate. PTSD claims cost more on average, workers spend more time off work, and fewer workers return to work compared to other workplace injuries. However, QPS has work to do if employees are going to properly utilize the system that is put in place to recognize and respond to psychiatric injury in the form of PTSD among police officers. Trust appears to be one of the main issues which will be explored here. So QPS as an employer owes a non-delegible duty to employees. Special dependence or vulnerability is an issue, as is the system that's put in place by the employer. So you can elect between action and negligence or no-fault compensation. This is covered by the Workers' Compensation and Rehabilitation Act. So the degree of permanent impairment is important. Section 188 discusses if the worker's DPI is 20% or greater. Section 189, if it's less than 20% or non-existent, the worker must make an irrevocable election between lump sum compensation or seeking damages. So for less significant injuries, workers can access compensation sooner and with less difficulty by electing no-fault compensation. For more significant injuries, workers can accept compensation and still seek negligence damages. However, if successful in negligence, the compensation lump sum payment must be returned. So the current negligence law relating to psychiatric harm in Queensland is covered by common law. The touchstone of liability remains reasonableness of conduct. Other jurisdictions have taken deliberate steps further back into the rear behind medicine. Queensland, however, arguably has not. So Queensland still uses common law precedent, the calculus of negligence from Shirt. We've balanced the probability of risk, the gravity of harm, practicability of precautions, social utility of the defendant's conduct, and other factors such as conflicting responsibilities. So employee thoughtlessness is an issue, whether a worker agreed to perform the duties, and Justice Kirby said that the duties of police officers do not trump the duty of the employer. Kirby criticized the employer and the courts. Police officers repeatedly exposed to conditions of trauma, a culture traditionally unsympathetic to revelations of stress or weakness, cold, indifferent, lack of support, and the court turning its back on negligence, on accident prevention, indifference on the part of employers is restored and rewarded. Aftermath cases where police officers are attending a scene after the event. In Queensland, a driver who died in a single vehicle accident owed a duty of care to a police officer who suffered PTSD, whereas in Victoria, it was held that no driver owes a duty not to cause psychiatric injury. Very recent case, Kozarov in Victoria. If Ms. Kozarov, if reasonable steps had been taken for her welfare, then they probably would have revealed that she had symptoms of PTSD. She would have been moved out of her department and her psychiatric injury would not have been exacerbated. So breach is covered by the Workers' Compensation and Rehabilitation Act, Section 305B. I apologize that we can't go through these in detail. We're very pressed for time here. Causation is covered by Section 305D. The onus of proof, Section 305E, is on the employee or the plaintiff. Defenses, this is important. Contributory negligence can be a real issue. So there's a long list here of contributory negligence factors that are worth looking at. Don't drink on the job. So damages are covered by Chapter 5, Part 9 of the WCRA. This includes an injury scale from 0 to 100, calculations of damages, interest, future loss. Serious personal injuries are covered by compensation under work cover and the NIIS. So the duty approaches for employer-employee. Kirby in New South Wales and Fahey, the system must be enforced. This must be done even against employee resistance. And Justice of Appeal Keane in Hegarty and Queensland Ambulance said important values of human dignity, autonomy, and privacy are involved in the formulation of a reasonable system of identification of psychiatric problems. So at one end you have Kirby saying we need to enforce the system, and at the other end you have Keane saying let's respect the privacy. And this highlights a complex balance to be trodden by the courts and creates the risk that employers will be able to shelter behind asserted concerns for employees' rights to rationalize their failure to respond to signals of incipient dysfunction. So my advice to you, speak up, seek help, put it on record. Don't let your employer neglect their duty. No fault claims. Work Health and Safety Act. The Act aims to reduce risks, ensure safe practices, ensure the law is followed and enforced, etc. Who is responsible? The employer and the worker as well. Who is covered? Workers and the general public. So the Workers' Compensation and Rehabilitation Act establishes a workers' compensation scheme for Queensland, encouraging improved health and safety performance by employers. So workers are covered for injury at work, and these sections discuss what a worker is, what an injury is, and what work is. So available benefits are covered under the WCRA. Again, I apologize that we can't go through these in detail. So the claims process, as you can see, can be quite convoluted. It's important to know, and to get advice on which way you want to go. So a 5-year review of the scheme appears to be lacking in terms of providing the tools to support employees to facilitate early intervention and support services to workers who may be suffering from a psychiatric or psychological disorder during the claims determination period. The best approach would be for insurers to meet the cost of a prescribed number of psychological treatment services up until the claim is decided. Nothing is done. The cost of mental illness is high, but early action at the workplace will very possibly reduce that cost for employers and will especially reduce costs for workers and society as a whole. So the scale from psychological health to psychological injury. Now, psychosocial hazards at work for police officers, of course, there's a lot of them. And when they're frequent, prolonged, or severe, we have psychological harm and physical harm. Mental disorder claims, median claim much higher than other claims. Workdays lost much higher. Mental disorder claims, defense force, firefighters, and police, again, cost much higher. Average workdays lost much higher. So Queensland Audit Office, managing the mental health of QPS employees. How are we doing mental health and well-being strategy? Obviously not very well. And then injury claims against the QPS. Psychological claims alone account for a huge element. These officers are on the front line and arguably are at the highest risk, but for the reasons we covered, the service does not monitor their mental health. So the claim rate, defense force, firefighters, and police, much larger than other fields, and female officers, much higher numbers, unfortunately. So this report sought to answer whether QPS is effective in the prevention of mental illness and the monitoring of employee mental health. QPS does not communicate and market its support services to employees as effectively as it could. There's a level of mistrust and lack of confidence. The extent of the mistrust is not clear, but on face value, it is pervasive. Human services officers are a critical component. They're either qualified psychologists or social workers, but there's a level of mistrust and a misunderstanding about their role. The employment of QPS HSOs and the work they perform is governed by the Code of Conduct, professional codes of ethics, and the professional registration bodies. Any breach would have consequences, but mistrust of human service officers is widespread and an inhibitor to employees seeking help. They said there was a common belief that confidential information is reported or available to management, and that as a result, disclosing information to them is potentially damaging to the career. Some officers advised that they had engaged and paid for psychologists privately because of their mistrust. I spoke to a senior constable who obviously wanted to remain anonymous. He said, if you actually report PTSD symptoms, they start combing through your entire history. They'll look for reasons to get rid of you. That's actually one of the solutions they come up with. Especially because you carry a firearm. They'll find some little thing you did, and another, it's all recorded. It's there forever. All your reports, your keystrokes on your computer don't disappear. You can type something, delete it, and they can still see it. So you don't mention it, you try and cope, you hide it, then you blow up one day. So the police commissioner, of course, responded to the audit. Understand some people may have this perception, but the audit team couldn't, show any evidence to substantiate it. Since establishing a system in 2008, only one complaint regarding a possible breach of confidentiality, which was ultimately not substantiated, had occurred. So if the official response to an audit is this defensive and potentially dismissive, then QPS indeed has work to do. This presentation has sought to address issues around PTSD among QPS employees and clarify the current laws relating to claims in negligence and no-fault schemes when PTSD is suffered at work. Employees may have a choice between negligence and no fault. This should be carefully considered as the election may be irrevocable. We've discussed the cost and delay of PTSD claims. The current effectiveness of QPS has been discussed, highlighting the major issue of mistrust. It would appear crucial for QPS employees to speak up and seek help despite shortcomings of the current support system. The Commissioner himself ensured that employee mistrust is misplaced. The health of police officers and the public is too great a risk to ignore. Thank you.